Hello and welcome to another podcast exclusive with The Caring View. In today's episode, we are going to be exploring the new Worker Protection Act. This podcast is brought to you by our sponsors, Attis Care Insurance, Care Business Associate Training, and Prosperwell Marketing. Alongside the podcast today, we also have a fantastic ebook designed to help you and your organisation get prepared for the new Worker Protection Act. So be sure to head on over to our website, www.thecaringview.co.uk, to download this for free. So I am delighted to be joined today by Mark and Stephen from Stephen Scown Law Firm. Good morning, Mark and Stephen. How are you both?
Good, thanks, Mark.
Good, thanks, Mark. Good to speak to you.
Yeah, no, thank you very much for giving up your time to join me today. Are you both able just to do a quick introduction to yourselves and what role you play within Stephen Scown? Mark, if I come to you first.
Sure. So my background is in operational HR, but I joined our firm 8 years ago. So I'm part of our employment law team, but I spend the majority of my time advising small to medium-sized employers with their HR matters, including this kind of on-site support that many of our clients need if they don't have a HR specialist in-house.
Perfect. Thank you very much. And Stephen?
Hi, I'm a regulatory compliance and enforcement partner with Stephen Scone. I joined the firm just about a year ago after 22 years working for a transatlantic law firm. I work across many sectors, supporting clients involved in health and safety, executive investigations and prosecutions, interaction with CQC, safeguarding incidents and inquests, and also risk management and compliance to help them maintain and achieve compliance. I would see myself hopefully as the fence at the top of a cliff rather than an ambulance at the bottom.
Well, welcome both of you. So we're here today to discuss the Worker Protection Act, which is a new duty on employers, which comes into effect from October 2024 under the Equality Act. I was just wondering if you could both, or one of you, just explain what the new Protection Act means that will come into effect, and how will it affect employers' obligations, especially around sexual harassment and prevention.
Yeah, so I'm gonna take this one, Mark, because that's more my area. This is going to increase an employer's obligations to protect employees against sexual harassment. And without getting too much into the legislation, the Equality Act defines sexual harassment as unwanted conduct of a sexual nature that has the purpose or effect of violating your dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So quite a broad definition, but with that conduct of a sexual nature part within it. Now, there's already a potential legal defense if you're an employer to a sexual harassment claim, if you can show that you've taken reasonable steps to prevent that happening. But the new legislation takes this further by putting a legal obligation on employers to take proactive steps to prevent sexual harassment taking place. So I'm thinking of this as a prevent duty. So obviously there are employers who deal with this issue robustly and proactively, but the potential for reputational damage for not doing so is significant. I was drawn to, for example, McDonald's was one of the businesses to face that following a BBC investigation that revealed various allegations in terms of alleged culture within their business, and a very high-profile thing to be facing. The new law was primarily introduced to protect women, although all genders are, of course, at risk of sexual harassment and are protected under the new legislation. against unwanted conduct of a sexual nature. If employers get a claim for a breach of the new duty, that can be made in the employment tribunal, but it has to be attached to a claim for sexual harassment itself. So this is not what we call a freestanding claim. In reality, claimants would just add a claim against the employer for a breach of the duty to take steps to prevent. And if an employer is found to have breached that new duty, it could be subject to two main things. One is enforcement action by the Equality and Human Rights Commission, or an uplift, a financial uplift of up to 25% in any compensation awarded if a tribunal finds that an employee has been subjected to sexual harassment and the employer has failed to take reasonable steps to prevent it. So it really has some financial teeth, this as well.
Yeah, no, thank you very much. So you spoke there about that from your perspective, it's a focus on prevent. Are you able to share any steps that employers could take to comply with the new legal duty? And should they be communicating, or how should they be communicating these to their employees?
Absolutely. So first of all, it's correct that the legislation was drafted to include that an employer should take all reasonable steps to prevent sexual harassment, but final legislation was watered down slightly by removing that word all, but the Act itself doesn't spell out exactly what reasonable steps are, however. Now, one thing for employers to look out for, the Equality and Human Rights Commission are due to update their technical guidance around this to reflect the new duty, setting out the steps that employers should take. I checked back yesterday, it hadn't yet been updated, so do watch out for that as we get closer to October. But in the meantime, the current EHRC resources from January 2020 are the things that employers should refer to. So before we just go on to some of those reasonable steps, it's worth also mentioning that Parliament also voted when this legislation was going through to remove a clause that was in the draft legislation that would have restored what we call the third party, such as customers, clients, residents, harassment provisions that were in the Equality Act in 2010, but were repealed back in 2013. But it's important to remember that employers can still be liable under the existing law if you fail to adequately deal with complaints from employees relating to third-party harassment. So obviously in the care sector, service users, clients, residents, potentially. And the EHRC guidance already states that third-party harassment should be addressed in your policy work. And the last thing to mention on that is that if the Labour Party wins the next general election, it has indicated a move to reintroduce that statutory liability for third-party harassment. So again, that's something to look out for. So thinking about those steps that should be taken, obviously every sector and every individual workplace is slightly different and will have different risk factors and therefore potentially different reasonable steps to mitigate. I would say in the meantime, as a minimum, there are some things employers should be doing. Number one would be introducing or more hopefully updating your policies and procedures that deal with sexual harassment. Secondly, obviously making those clearly available to staff, but supported by some really good communications work reflecting the importance of this issue. Alongside that, I think is really looking carefully at how you support staff to speak up about potential sexual harassment where it's taking place. Fourth would be really consider how you apply a risk assessment approach to sexual harassment as you would do with any other health and safety workplace risk, considering closely the risk factors, how you might mitigate them. And finally, my last key action would be to provide relevant and regular training to staff members and to new staff members. but happy to go into a little bit more detail on that.
Yeah, no, thank you very much. And I think the things that really stuck out to me there was around that communication and the training and having that culture of your staff being able to feel that they can speak up and speak out. Is there any advice there around how organisations can create that culture based on what you've seen with other legislation within the workplace?
Sure. I would say, like anything with workplace culture, it's a culmination of a number of things done consistently and done well over a period of time. I think there is a key point here about genuinely consulting and involving staff. And when we're talking about sexual harassment, I think firstly that's in creating safe spaces, really challenging yourself to look at how you can create a genuine speak up culture. Perhaps some trained individuals as contact points who aren't HR or aren't senior leadership. Similar in some ways, perhaps, to what a lot of good employers have done with mental health first aiders. So you've got more than one person that an employee can potentially go and speak to. But at the same time, making clear who are the responsible staff for any reporting. I think good employers will ask and include in their staff surveys where they think practice can be improved in this area. Employers should also look at links to your whistleblowing policy, including whether, obviously for some large employers, if you use an external whistleblowing service provider, and what happens if concerns are raised via that route. Also looking at what you might do if you get anonymous concerns, and looking at data from exit interviews. So I think that's how you really consult and involve. There are lots of other things. I would direct employers towards the EHRC. Have got a checklist, an action plan for employers published on their website around preventing sexual harassment, which is based on some work they did with the UK hospitality industry a couple of years ago to develop this. But it's a useful tool for any sector in reality. So you can go in and use that to develop your own action plan. And that will talk about carrying out risk assessments to really drill into the specific risks in your workplace and how you would mitigate that. Now, yes, that will differ by workplace, but I'll give you some perhaps more detailed examples. Number one, who has power over matters like staffing hours, rotas, breaks, incentives, and how do you ensure that those powers aren't abused? When we talk about the degree of control certain employers may have over others. An obvious one is environments where any alcohol is present. Third one I would flag is anyone attending visits or meetings, or indeed caring for clients alone, rather than as part of a larger team. Then we have obviously specific risks from particular individuals or clients. For example, capacity issues may come in here, or unpredictable natures, particularly around a sexual nature, or someone with a previous history of the same, or of a volatile nature. How do we risk assess those specific clients? Then more generally, there are things like social events. Many employers now will do very specific communications for example, annual social events. You've got environments where there might be high pressure to keep key customers happy. And what about the working environment or spaces, even lighting to make your spaces safer, including staff restrooms? So you can get very, very specific with this, and the best employers will be doing that. I think there's another culture piece about senior leadership pushing this up the agenda. For example, perhaps appointing one of your senior management team to drive the delivery and the communications across the organisation on this. The best culture change pieces I've seen is where there is really a senior sponsor who drives it. There are a number of other points around the policy and procedure aspect. I would encourage people to do a real thorough review of those, and ensuring that clear standards and communication of expectations are really in place, and the policies that are related to this. So if you have a working alone policy, if you have a staff relationships policy, and also agreements with agencies that you work with that make clear what to do if their staff are experiencing sexual harassment while working with you. I've mentioned regular training, so making that's not just a one-off, both for managers and for other employees, including for staff if they observe this happening amongst the teams. I think there's a piece around no tolerance communications, so not just to staff, but to contractors, freelancers, visitors, clients, or similar, that this is something that's clearly brought to people's notice. Employers should definitely review and update your reporting system and procedures for harassment if allegations are made. An obvious one, but sometimes forgotten, I think, is making sure that you deal with every single complaint seriously, promptly, and confidentially. That is very much part of a culture of zero tolerance on this. And part of that, of course, is being absolutely willing to take appropriate disciplinary action. A robust, accountable approach to where this happens should reduce the likelihood of recurrence, and is of itself a reasonable step in the context of any future complaints. And the last few points I would make around culture is, do make sure you're monitoring the understanding of policies and the effectiveness of the protective measures that are within them. I would also have a think about gaining a better understanding of who or which groups are potentially at higher risk in your workplace. Now, for example, the research says that there is a higher risk of sexual harassment for employees who may have intersecting or multiple strands of discrimination factors, such as race, disability, sexuality, or if English is not their first language, and age. So do think about whether your communications on this addresses those groups effectively. For example, those staff where English may not be their first language, are they getting the same level of appropriate communication as other staff? And the last things I would mention is this also links to addressing or other work you might be doing on addressing gender inequalities in your workplace, such as female progression to senior leadership, managing maternity return to work, gender pay gap. To some degree, these are matters that are all related. And finally, make sure you're monitoring your incidences and reports and what action was taken, and reviewing any lessons learned. That's all part of a good culture. And the final thing I would mention is signposting other potential support. So if this is happening to somebody, not just perhaps a bland reference to your employee assistance program, but also other things like, in the worst case, victim support or Samaritans or Mind. So yeah, good signposting. I appreciate there's a lot there, but I think they're all small building blocks in building a much more positive culture on this.
No, absolutely. And I was scribbling notes down there as you were speaking, and I'm definitely going to have to go back and listen to this recording. But it feeds into so many other parts of the business, and I do feel like from listening to you there, it starts to kind of triangulate how we can protect employees. And I think you've given some really tangible tips that providers can start to use and to think about to protect their employees and the workforce.
Sure.
I think it was good there that you spoke around the senior leadership. That's got to come from the top. And I think that lines closely with the new single assessment framework by the CQC, because they've got in there around leadership and having the same vision and values and bits and pieces within the workforce. So that ties in there. And you spoke there about kind of complaints and the transparency around complaints. And again, in the new single assessment framework, the CQC expects providers to be transparent and to make sure that they're investigating all concerns, however small, however big, and actually going back to the person that's raised them. But yeah, no, thank you very much for sharing
Pleasure.
so many great tips there. I want to come on to around the health and safety focus on violence and aggression. And Stephen, I was wondering if I could bring you in here just to recap on what the law requires from the context of health and safety.
Yeah, thanks, Mark. Of course, I can summarise the law in England and Wales relating to work-related violence. Just a starting point, what I mean by work-related is violence that arises out of or in connection with work. And that could be in the retail, healthcare, hospitality and leisure or education setting. But there are just really a couple of specific pieces of legislation that I thought would be helpful to raise that employers and other duty holders should be aware of. Firstly, the Health and Safety at Work Act 1974, and secondly, the Management of Health and Safety at Work Regulations 1999. So sections 2.1 and 3.1 of the Health and Safety at Work, etc. Act 1974 impose non-delegable general duties on employers. So firstly, the duty owed under section 2.1 is to ensure, so far as is reasonably practicable, the health, safety and welfare at work of all of their employees. Welfare being an operative word, an intentional one there. Section 3.1 is very similar. That's the duty owed by employers to non-employees, such as visitors, patients, customers, guests and contractors. And that duty is for employers to conduct their undertaking in such a way as to ensure, so far as is reasonably practicable, the persons not in their employment who may be affected by their operations are not exposed to risk to their health and safety. So in short, employers need to assess the risk of work-related violence and aggression and take an account of the likelihood of a violent or abusive incident or situation occurring, and then to weigh up the time, cost, and effort needed to reduce that risk and to put in place reasonable proportionate measures to control that risk. So what will be required will depend on the likelihood of a work-related incident occurring and the impact of that incident if it was to manifest itself. So the higher the risk of an incident and the higher the risk of serious injury, the more time, effort and expense to control that risk will be expected. So a key takeaway for those listening is really the duty owed under sections 2.1 and 3.1 of the Health and Safety at Work, etc. Act 1974 requires material risk to be controlled. And if a material uncontrolled risk exists, then that in itself is enough to amount to a breach of the employer's general duty. An important principle following on from that, which is often not fully appreciated, is that proof of actual harm is not required for a breach, and therefore an offence, a criminal offence, is made out even if there is no physical or psychological injury or harm. And just the second piece of legislation I mentioned is the Management of Health and Safety at Work Regulations 1999. Regulation 3.1 requires employers to make suitable and sufficient assessment of the risks to the health and safety of employees and others who may be affected or impacted by their operations. And again, if you employ more than 5 people, you've got to record that risk assessment in writing. In many sectors, work-related violence will be a material risk, and therefore employers are required to assess and control those risks as part of their overall health and safety management arrangements and record what controls and measures that they've put in place and what staff and others need to do to not be exposed to a risk to harm. And again, another important element which is often overlooked is that there is a specific obligation under the management regulations on employers and duty holders to review and revisit their risk assessments and control measures where there is cause to suspect that their existing controls and measures may not be suitable or sufficient. So in short, my advice would be to take the time to review applicable risk assessments where an incident, and that's just not a lost work time incident, but a near miss has happened, which could lead to harm. Because if that has happened, then there really is need to look at your control measures and really take a view on what extra can be done to avoid that incident reoccurring.
Yeah, no, thank you very much. And listening to you there, I think historically health and safety has kind of got the raw end of the deal. I think because we've had an act that has been there for so long and it hasn't necessarily changed. And I know when I speak to staff, it's always the health and safety training that they kind of the begrudge going on the most, just because of that lack of kind of any change and the constant. And listening to you there, I feel that actually this new Worker Protection Act is really actually going to help elevate the importance of health and safety in the workplace, and I think it will be a change, and I think that's going to be a positive thing for all sectors, not just social care. And you spoke there around core measures, which I do want to touch on with you, but I just wondered if you could just kind of break down some of the key risks associated with kind of physical or mental violence and aggression in the workplace.
Yeah, absolutely, Mark. And just to add to that, I completely agree with what's been said. And also, over recent years, as part of the HSE's long-term strategy, there is an increased focus and commitment to really driving down occupational risks and maintaining health and well-being. And it's not a case of HSE and therefore employers just looking at those traditional risks of a fall from height or an unguarded piece of machinery. It's really looking at harassment and other occupational risks such as work-related violence. But just returning to the question you posed, the key risks really, very similar to what my colleague Mark said, really depend on the sector the duty holder is working in and the type of activities being undertaken. But some of the key risks will involve, particularly from a healthcare setting, those with lacking capacity, with cognitive impairment and sensory loss, mental instability, where their behaviour often unpredictable and volatile. Also working in an environment where customers and service users could become impatient, resentful, or frustrated. Also in an environment where alcohol is served and consumed, where that can rapidly change behaviours. Where staff exchange money or have access to cash and valuables. That's often quite a key area for those with criminal intent. And also workloads and pressures in an overly toxic workplace culture, where there is high demands and targets set. They're some of the key risks that I think are present.
Thank you very much. And you obviously mentioned earlier around kind of measures that employers can take. How can they proactively identify and assess these risks?
Again, that's really down to the sector and the type of work being undertaken. But a starting point, which Mark really raised, and experience of over 20 years that I've seen is invaluable, is twofold. It is the board level commitment to ensuring that there is a safe culture and that's maintained. But also secondly, those in an organisation with responsibility for compliance and health and safety really need to have a joined up approach with their employment HR colleagues, just to make sure across the organisation there's that clear understanding of what needs to be done, and there's consistency of approach and action taken. So I think that's absolutely key. But also, other key factors, it is really employers should really use their own knowledge and lived experience. They are best placed to understand how their organisation operates, what the risks are, and what degree of risks are posed from hazards and situations, and also having regard to information and guidance that's there. It's there in many forms, often which it's freely available. Industry guidance, for example, and what is going on elsewhere in your sector. Because if something were to happen and the duty holder was to be the subject of enforcement action, available guidance and what others are doing, can and often will play an important part in determining whether the controls and measures taken are indeed reasonably practicable. And another issue again, I will probably touch upon it a few times, is listening to their employees and actively looking to reporting of concerns. And that's just concerns about unsafe working environments and practices, and also incidents. Even if they are near miss incidents where there's been no actual lost working time or harm. And again, looking at all of those issues to really take time to think about the likelihood of harm and the risk of harm and the level of harm that could be created, and just to really think, what can we do that's effective and proportionate to put measures in place to stop an incident or a risk of harm actually manifesting itself.
Thank you very much for that. Just listening to you there, I know that obviously previously you'd mentioned healthcare, we're obviously social care, and you'd mentioned previously around hospitality. Are there any sectors that face higher incidence rates? And if there are, do you know why that is, or do we have any kind of inclination of why that possibly might be?
Yeah, I think the sector that people are working in, some are higher risk than others. The retail sector, for example, there is a higher risk of theft, other forms of criminality, and customer abuse, public disorder, antisocial behaviour. And some listeners will be aware of last week's government announcement of its intention to introduce a new offence of assaulting a retail worker as part of government's longer-term retail crime action plan. Again, hospitality, it's been mentioned by Mark, that's behaviour linked to alcohol and drugs, but also increasingly customers' sense of entitlement and rudeness and propensity to be verbally and physically aggressive in certain situations. Healthcare, again, a major area that I work in. The cause can be voluntary and involuntary in my experience, again, due to capacity issues, cognitive impairment, patients with dementia, psychological instability, and also behaviour influenced by medication from a service user's point of view, and also where you're on a frontline primary care setting, such as a hospital, those under the influence of drugs, alcohol, or suffering an acute stress or anxiety episode, whether or not related to medication. And also another sector where there is very significant, as with the others, higher risks of work-related violence is education, where you have pupils with behavioural issues and also those with special educational needs, where again, due to cognitive impairment and capacity issues, their actions are often sudden and unpredictable.
No, thank you very much. And I think you spoke there around retail, and I think we all see the CCTV recordings on our social media and on the news. But I think just listening to you there talking about schools and some of the other sectors there, of the violence at work that we often don't see and we don't hear about. So I think it's great there that actually you brought some of them to the forefront. And thank you for breaking down kind of the health and safety focus on the Worker Protection Act there for us. I want to move on to kind of prosecutions and the regulatory intent. And I was just wondering if one of you would be able to share some kind of examples of health and safety prosecutions that are related to kind of workplace violence and aggression that we've already seen kind of in the public domain already.
Yeah, I'm happy to pick that one up, Mark. Just over the last year or two, there have been several notable prosecutions effectively emphasising the regulators' increased focus on maintaining occupational health and well-being and controlling those work-related violence and abuse risks. Just some of the cases that I would just touch on is the HSE prosecution of Park Care Homes No. 2 Limited and Priory Central Services Limited. In this case, their combined fines of £400,000 were imposed following the sentencing hearing in July 2023 for failing to have adequate arrangements to effectively plan and organise preventative measures to minimise violent acts towards staff and other patients at a psychiatric hospital. Another case is, again, an HSE prosecution against Serco Limited, where a £2.25 million fine was imposed as a result of multiple failings associated with the death of one of Serco's escort staff, following an assault by a prisoner who had a known history of violence. Some of the failings that were reported include a lack of information sharing, training and preparedness, and really planning, essentially, as well as inadequate staffing levels. They were all found to be causative factors in this risk manifesting itself and the sad incident happening. Another case is G4S Care and Justice Services. They were fined £250,000 as a result of an employee suffering life-changing injuries when he was assaulted by 4 individuals at a young offenders training facility. In that case, there were not dissimilar failings to the Serco case. In a different setting, this one being education, Luton Borough Council were the subject of a prosecution by HSE and were fined £104,000 due to failings to have arrangements in place to minimise the risks to safety arising from management of pupils with known aggressive behaviours. And a last case, CQC, it really emphasises the growing focus on the role and culpability of individual duty holders, not just the organisation. In this case, the registered manager, Denise Clark, was fined for failing to prevent harm to other residents from a male resident who had previously carried out sexual assaults on other service users. I would just add that in addition to obviously the most significant form of enforcement action, prosecutions, HSE and other regulators have the enforcement powers to take other forms of enforcement action, such as serving improvement notices and notices of contravention, where there is a material failure to minimise workplace violence. And while stopping short of prosecution, even these forms of less formal enforcement action can still have a significant impact in terms of reputational harm, adverse impact when the duty holder is applying and putting themselves forward for tenders, as well as the risk of demotivating staff, and also having that working environment where staff can be less willing to embrace working environments and effectively, sometimes in the worst cases, really are unhappy and dread coming to work. So there's a loss of staff morale as well.
Yeah, no, thank you very much. And it's interesting listening to you there about some of those examples and the cases that have happened and how we don't really hear about those in kind of the public domain. And I'm sure if you follow health and safety really closely, you probably do, but not in the kind of the wider space. Just listening to you there around those kind of hefty fines and the seriousness there of those kind of prosecutions, but also the reputational damage that it does to kind of your brand and the impact of team and morale. And I suppose it goes back to what we were speaking about right at the very beginning around actually how we need to improve the culture within the workplace. Conscious that there might not have been that awareness for a number of managers and leaders out there, are you able to share any tips off the back of those incidents that organisations can learn to prevent similar incidents?
Yes, well, I think it's all about recognising and acting on near misses and incidents. Just learn what's going on, or be appreciative of what's going on in your own working environment, what's going elsewhere in the sector, and as just say again, just do not underestimate the importance and value of a concern being raised or a near miss incident happening, because they are really invaluable in telling you that possibly your control measures are not as efficient or as effective as they can be, and to really look at those. Because if you don't, the impact of that are numerous. That if you don't take steps, then there is that risk of a similar incident happening again, because if a near miss incident has happened, an occurrence of some sort, that's evidence in itself is, this is a material foreseeable risk in your organisation. And often where an incident has happened, where a formal investigation is being undertaken with a view to potential enforcement action, including in the form of prosecution, the regulators, including HSE, will look at previous incidents to see what you've done. And if there are previous incidents and you haven't taken any or any suitable steps, then they could be really found to be an aggravating feature, which will not only increase the risk of prosecution, but also the potential penalty that might be imposed.
Thank you very much. And you spoke earlier around the regulators and the enforcement action, and obviously I spoke about the lack of awareness in general. I was just wondering, what role do kind of regulators and industry bodies and unions play in kind of raising awareness, doing lessons learned, and enforcing kind of compliance within organisations?
They are vital sources along with your own staff, because those organisations produce valuable and practical guidance on what the law requires, what employers need to do to comply with their legal obligations. And as I say, what's going on in sectors, their own sector and other sectors that might be relevant in terms of enforcement action, emerging risks, and existing risks, and how to go about controlling those. So there are a number of sources, but regulators, union and industry bodies, really do play an important role. And just for an example, with HSE, they have got a wealth of freely available resources and guidance on their website. And again, it's really take time to have a look at what HSE's website contains in your sector, and take time to benchmark it. Are you doing enough? Is there a compliance gap between guidance and what you're doing?
No, thank you very much. And please, you mentioned HSE there, and the resources, because I was going to ask you if there was anywhere that people could go, a centralised place to kind of get those lessons learned and to see kind of what is happening kind of around us in other organisations. I want to talk finally on the last section of this podcast around balancing employee rights versus kind of the organisational safety. We obviously live in a culture of freedom of speech, and I'm all for that, but we also live in a very much a claim culture. How can employees strike a balance between respecting employees' rights, such as that freedom of expression, versus kind of maintaining a safe and inclusive workplace?
So I'm happy to pick that one up, Mark. The truth is, striking that balance can be tricky, particularly where you have views or beliefs which might be connected to one legally protected characteristic, where those perhaps what I would describe as bump up against the rights or beliefs or values of someone else, or another group with another protected characteristic or characteristics. There are things employers can do. What I would say when I reflect back on some of the cases around this is take advice. They can be complex, and they can be high risk when we're talking about discrimination claims potentially in employment. Those are uncapped, so they are tricky. However, there are things that can be done. So really clear policies on what is and what is not acceptable in your workplace. Now, from my experience, I would say that no employer that I come across is really in the business of trying to impose a single worldview, if you call it that. But employers do have the right to implement and act upon the policies that are designed to reasonably prevent employees from suffering harassment and or discrimination, not least to protect the business from legal claims against it, or individuals within that business, particularly if employees choose to bring those actions or those views or expression of those views into the workplace in a manner in which causes distress to other people. But I don't pretend that every situation is straightforward, and they each should be considered on its merits. And I think then you come back to points we've already touched on, really, is around effective communication of those policies. So not just an approach which says, see our handbook, that you've got some effective training that underpins that, to leave employees in no doubt of your expectations, that while you respect people's right to hold certain views and to express those views, that there is a line if they express those views in such a way to cause distress to other people. And then if concerns are actually reported, again, it's taking them seriously, acting promptly, keeping an open mind. I investigate first to establish what the facts are, because in every situation in employment law is fact specific, and going on to take that robust, reasonable action where the evidence warrants it. Talking as we did earlier about culture, people will notice if perpetrators of harassing behaviour are dealt with firmly over a period of time. But equally, we have to balance out considering alternatives to any last resorts like dismissal from someone's employment. And I would always say, working in employment law as I do, is take advice before you effect any dismissal, particularly in these types of cases.
No, definitely, and I think for anybody listening, you definitely need to be seeking advice there before doing that. And I think you spoke there around culture, and I think that can be a really hard thing to change. And I know when I've done turnaround manager roles in the past, that's not something that happens overnight. And you spoke earlier around kind of people's beliefs, people's values. Are there any practical steps that organisations could take to address kind of some of those ingrained behaviours that might contribute to violence or aggression in the workplace?
I think from the employment aspect, and Steve may have other things to add, it's all of the things that we've discussed as we've gone through the podcast. And I couldn't agree more. This is about culture change, which takes time. And to me, effective culture change is about lots and lots of small actions that add up to a lot over a period of time. And I appreciate in a turnaround situation, you try and put your foot on the pedal to try and accelerate that, and you can to a degree, but it does take time, and it takes consistency.
And part of that turnaround is around building trust with your employees. There's a lot of change happening, a lot of things that you might be introducing and doing, and you might be seeking legal advice. On the other hand, you've also got the people that you're supporting, their relatives, the public kind of viewpoint. From your experience of supporting organisations, how can businesses build trust, both with employees, but also kind of the relatives, the people that they're supporting, the public, by kind of showcasing how they're addressing any issues that might present themselves?
I think it's consistency. It's being robust. So if there is evidence of wrongdoing, that they are acted on. Some of the more difficult situations I come across from time to time is where we may be looking at a matter where, for example, sexual harassment is being alleged, and it turns out that this is not the first time that it's been alleged, and perhaps on reflection, when you look at it, has effective, robust, consistent action been taken in the past, and it's not always the case. So I think again, it's adding up all of those small actions, but being firm enough to take that robust action. I think that's ultimately how you build trust, and also how you build a good employer brand as far as you possibly can in the local environment in which you're working. People talk, people will exchange views online. Your employer brand is out there, whether you like that or not. So it's consistency, robust action for me, that builds as good a position as you can.
And if I just build on from that, thanks, Mark. A positive governance, demonstrable positive governance, is key across the organisation to really promote that safety culture, but also employee empowerment. and recognition of their own responsibilities, because we've spoken about sections 2 and 3 of the Health and Safety Work, etc. Act 1974 in terms of the organisational duties, but in terms of individuals, employees have specific duties under section 7 of the Act in terms of ensuring the health and safety of themselves and others, but importantly also helping their organisation to control risks and to manage safety effectively.
No, thank you very much for adding that in there at the end. And I think it's definitely around how we communicate that message back out. And I think sometimes it is hard, especially if there's a case going on, or you don't always want to kind of divulge what's happening kind of in the public domain, but how you manage that kind of negative impacts. You spoke there around social media and kind of people commenting in bits and pieces, and before you know it, it can really fire up and erupt and be all over the internet.
And if I could just that one thing there, Mark, that comes to mind is one of the things that is worth taking advice on is obviously from an employee point of view, if you're the subject of if you are the subject of harassment, or if you have witnessed harassment, it takes a certain amount of courage to report that or give evidence in relation to that. So again, I would encourage employers to take careful advice around the tricky issue of getting people to a point where they are comfortable to provide that evidence, because there are some traps to fall into around, for example, promising confidentiality or promising anonymity, and in the employment sphere, that's not. It's something you need to take advice on before doing, particularly if someone is working as an investigator. Looking into allegations of harassment, that needs to be really carefully handled.
No, absolutely. Mark, Stephen, I want to thank you both for joining me today to discuss the new Worker Protection Act. Mark and Stephen are from Stephen Scone, a law firm with a reputation of doing things differently. They've been supporting social care providers and other organisations since 1938. And what I'll do is I'll make sure that when we upload this podcast, we share contact details for you both in the description. I know for me, I've taken away so much food for thought, and I've written down so many notes. I think you have both shared some amazing tips, tangible tips that providers, organisations can take away and embed. And I know for me, I'm going to go away and you spark something in me that probably hasn't been sparked when we talk about health and safety for a long time. But to go back to my core role and work out what we're doing well, what we could do further to improve. And as a regional manager in my core role, be definitely looking at how I can make sure actually that's embedded within the culture of our workplace. So just want to say thank you very much to both of you for joining me today, for giving up your time to kind of raise awareness of obviously the new legislation that is coming into place later this year. So thank you.
It's a pleasure.
No, pleasure, Mark.